Well, hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope that you enjoy this content, and today will be the day that I earn your subscription. And today is a special day because this live stream will be the 1000th video that is posted on my channel. 1000th video. That's a lot of content. That's a lot of discussion about law. And there's no end in sight. They keep making new law all the time. But yeah. And incidentally, we have produced more videos than that. Because, over the years, I've taken down videos and removed stuff that I, didn't like or, wasn't really working. So, we've done things and removed them from time to time. So we've done more than 1,000 videos. But this will be the 1000th video posted on my channel. Hello, Nate the Lawyer. Thank you for being here for the celebration. It is awesome. So, yeah. So I just want to start off by thanking people. There's a lot of people that need to be thanked. And a lot of people have helped get me here. And so I wanted to go through some of the people who have helped me to honor them as they have helped me. So I will start with Leonard French from the channel Lawful Masses with Leonard French. Leonard French is how I got my start as a YouTuber. I was watching Leonard's content for some period of time, months maybe, or maybe longer than that. Maybe it was a year. I can't even remember anymore. But I was watching Leonard's content for some period of time, and he was really enjoyable. And I joined his Discord, and then over the period of, 3 months or something, maybe 4, time frames are a little off here, so you'll have to forgive me. But over some period of time, I became known to the channel. I was like, I'd love to maybe be on your channel sometime. And he's like, okay, that's cool. So I did things where we were remote, where I was filming in Virginia and he was filming in Pennsylvania, and we went to each other's houses a couple times. He slept on my couch one time. He had a blow up mattress that I could sleep in his house because it was in Pennsylvania. So we'd visit each other's houses, we'd film content, and some of the content that's on there with Lawful Masses with Leonard French, I still really enjoy. Sometimes I'll go back and rewatch that content. And also, incidentally, for what it's worth, Leonard French's, if you go to his channel and you sort by most popular video, I think the video that I did of covering the Benton versus Blue appeal in the Fourth Circuit's like the fifth or sixth most popular video on his channel. So like one of his most popular videos is a video that I did. And I did it on my channel, and he said, "Oh, can I have a copy too?" And it's like, yeah, and it blew up completely. So that's pretty cool. And so I was on Leonard's channel a couple times. I forget how many, and then I started my own channel. And he was on my channel, and we filmed content in my channel. And he helped me get my start. So, I miss him because we used to live relatively close to each other, as close as Pennsylvania and Virginia can be. And now he lives overseas and I live in Texas. So, not so much with the visiting each other anymore and stuff. But, he helped me get my start, and I just have to say thank you. So the next person that needs to be thanked is none other than Nate the Lawyer, who is in the chat. Nate the Lawyer has been incredibly influential. As Leonard was leaving my channel, for his overseas trips and stuff like that, Nate was entering. So, that timing on that was kind of interesting. So, I had a new lawyer friend as my close confidant. Nate the Lawyer has been that role in the back half of my career, to date, at least. He's a wonderful guy. Love talking with him. Love his information. Love his knowledge. I love the way we think about things differently. He suggested to me the Toddy case. I'm not sure if I should thank him or curse him for that one, but either way, it was good for my channel. And Nate just calls me sometimes, and I just call Nate just to say hi. We're reasonably decent friends at this point, not just acquaintances. So Nate the lawyer has been really influential in my channel. I've got a new video coming up on his channel that we've filmed already and is being edited as we speak. So looking forward to that coming out, and hopefully that will help us grow. That's really awesome. Next person to thank, Nick Rikita. Nick Rikita has been a good friend to me. He is someone, I visited him. He lives in the middle of absolutely nowhere, let me tell you. But he's an interesting guy, and it was nice hanging out with him and his family for a couple days, being on his channel, live streaming from the vault. He's someone I need to collab with more, but he's had me on his channel. The way we got involved initially was through the Vic Mignogna case, right? So Nick Riccietta has done a lot of videos on Vic, and I produced videos on Vic and came up with some contrary opinions, and he invited me onto his channel, and he couldn't have been nicer. We had a very professional, very cordial conversation. It was a nice give and take. He showed me respect. He made me feel welcomed. He made me feel like I wasn't going to be attacked. So we just had a very nice professional exchange. It was really, really wonderful. And then from there, we went on to do more things together. And he's someone I talk to and I really appreciate. So thanks to him. And then we got some people who are who I've not collaborated with as much as I want to, but who are coming up in the ranks. Legal Bites, obviously. I'm looking forward to doing some one-on-one collabs with her at some point. Her channel's growing nicely, so it's been nice talking with her. Hogue Law, Richard Hogue, and Attorney Tom. I've done, I think, one video with each of them. I love to do more. And then Emily D. Baker, to collab with was fun. So, that's 8 different lawyers. Yeah, 8 different lawyers I've collabed with over the years who have helped this channel grow. It's been pretty awesome. So, good stuff for that. Rukita. Yeah, Nick Rukita. Yeah. So it's been really, really fun. So thanks to everyone. Thanks for the heart, Nate. It's been really great. I've really enjoyed this channel. I've enjoyed talking about things. This has been a lot of fun for me. I've been doing my day job for 14 years. And, while there's nothing left for me to learn at my day job. I understand it. There's nothing left for me to learn. So I find it a little boring. I'm good at it, but I know all the technical aspects, there's nothing new for me. So the one thing's nice about this channel is, and one of the reasons I talk about everything except my day job is because I get to learn things, right? I already have a broad education like every lawyer does in law school. And doing this channel is kind of like being in law school again, because you're reading every subject, right? You're reading all the things and you're learning things all the time. And it's nice because I'm learning so many more things, and I see old videos of mine and I'm like, oh, I didn't know this yet, or I didn't know that yet, or I didn't have a good as much hold on this thing or that thing or this thing. And now I have better holds on some of these aspects. Doesn't mean I'm an expert yet, but I can see my process of learning. And I enjoy that. I enjoy the learning, where it's like, oh, I made this, I made a mistake here or made a mistake there. And it's like, okay, I'm smarter now. So that was really cool. That was really cool about the channel and why it's so much fun for me. Every case is an opportunity to learn about a subject I don't know, and every opportunity to teach you about subjects from a whole variety of fields, which may or may not be desirable from a channel development standpoint. Maybe I should pick a smaller subset than all the appellate cases. Maybe that's too broad of a category, but until I can find out something better to do. All the appellate cases sounds fine. So, all good times. Yeah, and just want to say thank you ultimately to all the people in the channel. I want to say thanks to all the viewers. Without you being here, this channel would not exist. It would be very lonely indeed talking to nobody. One of the things, and I don't think this is a unique problem, I think anyone who has a specialty or a real strong interest in any subject would run into the same problem. So whether you're really interested in comic books or really interested in Star Trek or really interested in Marvel movies, maybe less with the Marvel movies for my example, or really interested in chess or something, it's unlikely that you can just walk into a bar, as it were, and just strike up a conversation, which is why I say maybe less about the Marvel movies because they're so popular. You probably are better off there. But, I can't just walk into an establishment and be like, hey, let's talk about law. It's not what anyone else there is into. And you'd be surprised. It's not even what a lot of lawyers are into. They like it, but they don't necessarily like talking about it. And it's there's a lot of introverted lawyers, I guess, more than you might expect. So, finding people to talk to about this subject is actually kind of hard. And it's one of the reasons I like this channel and one of the reasons that I have enjoyed getting to know these other lawyers that I've collabed with, because I found a group of people who are my peers who like talking about this subject. And you guys, the people watching this channel, you like hearing about this subject. You guys like learning. And I enjoy teaching. So without you being here, this channel would not, well, first of all, it wouldn't exist because it's just not fun. And second of all, it wouldn't be as rewarding. I feel validated knowing that I'm giving some kind of education. One of the things I've said before is that I effectively have hired myself as a law professor. And I kind of like that. It's like, who will hire you? How about you hire you, right? So, yeah. €5 from Chaos Out of Order. Thank you for the super chat. You mentioned changing your format by posting cases before enders read and then discussing them. Is that still coming? Yes, that will be something that we'll do, and it's just a question of how to do it in terms of the editing and formatting of it, because depending on exactly how I'm doing it, unless we want to have those things two weeks removed. So I'd post it, we'd discuss it on a Sunday, and then it would be posted whenever. But yeah, it's something that we're still going to do. But I appreciate the super chat. Thank you so very, very much. And Gabriel said, legal me harder. That's cute. That's cute. So I just wanted to say thank you. So let's just see if there's any comments, and thank you to all you guys who are here, all the uncivilians, the people who are super chatting, the people who are at least whetting my appetite about the possibility of this maybe being full-time someday. We're not there yet economically. This is not sustaining yet, but we're we're making progress. It's something that could be. So we'll keep working for, 200,000 subs and see if we can get there. Attorney Tom's gone there, and a lot of other people are up at that territory. So let's see if we can reach in those territories too. I think that'd be very, very cool. So let me just go through the chats real fast. Michael Arbert here says, woot, thank you. A. Hedinger here, getting me to getting you to the 1,000th video. Yeah, we're there. Congrats from Toledo. Have you got your party hat? No, I don't need that. Love your collabs with Nate. Thank you. JB, nice. Congrats. Thank you. H-Batch, admire your grind. Keep it going. Cody Sams, Tarek Twilight, Evil Lash. Sophie Long case is a bit of a nightmare. It's one of the reasons I don't want to do family law, preferably ever. Family law is just a pile of sad. Yeah. M. Gabriel, are we going to discuss the CDC here? Well, I wasn't really planning on it, but sure, why not? Let's discuss the CDC. So, yeah. So, the President Biden had said something like 2 or 3 days ago, we're not going to extend the CDC moratorium because it's unconstitutional. I think the CDC director might have said that 2 or 3 days ago. But, they've apparently decided it's constitutional now. And they've extended the eviction moratorium, despite the pretty clear language from Kavanaugh. Now, I wasn't as hard on Kavanaugh's reasoning as some other people were. A lot of people thought Kavanaugh was being a bit of a coward by saying, I won't rule against this because it's going to expire in 3 weeks anyway. And I didn't begrudge him that too much, because one of the things you think about is remedies, and there's an entire course on it in law school. Like, okay, so something has gone wrong. We've determined, the entire point of remedies is we have determined someone did it bad. And then the entire remedies class is, okay, now what? Right? We've determined someone did it bad. Okay, now what? And you can look to various different remedies. And I didn't begrudge him that decision too much, because basically the way I parsed it, or the way it makes sense to me at least, is, okay, it's naturally going to expire in 3 weeks anyway. People have built around this expectation, right? Landlords and tenants have built around this expectation. So there's a reliance interest there that matters, right? So the CDC not being able to do something is one thing, but the reliance interest, for good or worse, among the housing community has been established, and everyone has built their expectations on the fact that this is going to expire in 3 weeks. So to me, it's completely constitutional, or completely proper, to put it another way. It's completely proper for a judge to say, yes, this is illegal, but it's going to end in 3 weeks anyway, so as a remedy, I'm not going to do anything about it. It's going to naturally expire, let it naturally expire. So to me, I didn't give him that hard time. Now, if it were 3 years in the future, that would be a lot different, right? But saying, okay, it's going to end in 3 weeks, everyone's built their expectations. It's been going on for a year or whatever it is at this point, right? So this is, people have built a reliance interest around this for better or worse, so it's going to expire in 3 weeks. So yes, I determine it's illegal. No, I'm not going to do anything about it, because it's going to expire in 3 weeks, so let it not come to its natural end. So a lot of people called Kavanaugh a coward for that decision. A lot of people thought Kavanaugh, was just didn't have the merits of his conviction. I saw it as a more moderated decision. Rather than rip the Band-Aid off, it's going to end in 3 weeks anyway. Everyone's building their reliance interests around that. So let it be done, right? But apparently, because, it was just a one-man opinion writing for himself, Biden says, oh, okay, let's extend this for another 2 months. And I'm like, no. So all I'm trying to figure out right now is how fast can you get a decision to the U.S. Supreme Court, right? And I don't know if anyone's whispering in anyone's ear, but the Supreme Court can act really, really fast when it's motivated. So they need a district court somewhere to render a finding that this is improper. Maybe issue an injunction, because you can appeal an injunction, right? So maybe issue an injunction, appeal it. And then the Supreme Court can say, yoink, right? They can't hear in the first instance, but they can skip a step. It's called a certiorari before judgment. In this case, the before judgment will be referring to the Court of Appeals. So they're like, okay, notice of appeal, yoink, that's our appeal now. We're going to skip a step, and we're going to do this right now. So the Supreme Court can do that, and maybe they will do that just to smack him down. And I kind of hope they will do that. So we'll see if that's going to happen. But yeah, the fact that they extended it is blowing my mind. Not politically. Maybe it's just that they want the ability to say we did everything we can. It's that lousy Supreme Court. Maybe it's just a passing the buck move, which doesn't go a lot for the buck stops here. Right? So I guess Biden is not a believer in the buck stops here. So he's like, well, I can pass the buck off to the Supreme Court. So I'm going to extend it. It wasn't me. It was that mean Supreme Court, which is all the more reason we need Supreme Court reform, right? Ugh. Yeah, that's got to be the only reason. If these people think they have a legal edge to stand on, no. And the fact that the President of the United States and the CDC director are doing something that's clearly illegal is more than a little frustrating. So, that's annoying. Rikita, yeah. Isaac Hawkins, congratulations. Thank you, Isaac. A. Hanger says that they love doing that. I do the collabs. I love doing the collabs too. I love talking to other lawyers and getting their perspective. It's fun. I do more of them with more lawyers. Tarek says the collective knowledge is one of the greatest things about this type of community. That's one of the nice things about talking with other lawyers. They keep me in check, and I keep them in check, right? So I've corrected my fellow lawyers on a couple occasions. They've corrected me on a couple occasions, and sometimes we disagree, which is fine too. But yeah, that's one of the great things. The collective knowledge is a lot of fun. The Theater Doc says, I appreciate you and all the legal commentary creators you mentioned. I think it's made me better on the analysis of my non-lawyer job. Excellent. M. Gabriel says, this is my favorite law channel, but Grueler is going up. I should have thanked Grueler in the chat in the stream too, since I did a collab with him. So I need to edit that back in because I did do a collab with him and I don't want him to feel left out. So that's 9 lawyers I've done collabs with. So that's really cool. Let me go edit that real fast to give him some love. All right, so you can go after Emily at, let's see, Robert, Grueler. Great. Save. Fantastic. Noble Ward, talk legal to me. Respect. Extending it was great politically, long wait in court. It could be a long wait in court. Depends how motivated the Supreme Court is. I don't know if maybe one of the Supreme Court justices has whispered in some district court's ear. It's like, could you expedite this so we can, kill this thing? Because you can just do it because you already have the decision, right? You already have the decision. You already have the votes. So you don't have to have, and you don't have to do oral arguments. You can just do it on papers. So be like, granted, affirmed, order vacated, go away. Write your decision. So if the Supreme Court can ball when it really wants to, the Supreme Court can ball when it wants to. I try to remember how fast the Pentagon Papers case was. So the Pentagon Papers case was dealing with a leak of classified information during the Vietnam War that came into the hands of the press. And the U.S. government sued whoever it was. I think it might have been the New York Times. I can't remember. But they sued whoever and said, okay, you can't publish that because it's classified information. That case went from being filed in the district court to a decision from the U.S. Supreme Court in 10 days. That's how fast it was. It was one of the ballerest lawsuits ever. So filed in the district court, decided by the district court, decided by the Court of Appeals, heard by the Supreme Court, decided by the Supreme Court, 10 days flat. So the Supreme Court can really, really ball when it wants to. So maybe this will be one of those times. Yeah, I did a collaboration with Viva. Yeah, I forgot to thank him, but I did mention his name in chat. Yeah, Viva Fry has been a big influence on the channel. Big influence on the channel as well. I really enjoy him. I need to do more with him, to be quite honest. I miss him. That wonderful Canadian. So that's 9 lawyers I've done collabs with. The list grows. Yeah. Yeah, it is impressive. That is impressive. Yeah, being filed in the district court to a decision from the Supreme Court in 10 days. It might have been faster than that. Let me see if I can look it up. Yeah, so. Blah, blah, blah. The leak. It was the New York Times. Okay, yeah. So they obtained a injunction. The Attorney General and Nixon obtained an injunction against the New York Times to publish after they had already published 3 articles, and they got an injunction to publish any more. And that was on June the 14th. And then it was decided by the Supreme Court on June the 30th. So it was 16 days. Well, it went from the injunction being issued to being decided by the Supreme Court in 16 days. So, yeah. That's really, really cool. And that's New York Times versus United States. What a badass case that was. Yeah. So they can really, really ball when they're motivated. Runkle? Yeah, I should do a stream with Runkle. That'd be cool. Barn stream when? Probably not. So what else should we talk about? Well, I was watching an old episode of Law & Order, as one does. I rather missed the weekly lawyer chat. Sad to see you drop that. I'll probably bring it back. It's just, I just needed a break from it. But, I'll bring it back. I'll get back with them soon enough, okay? Yeah, I need to refresh myself. Yeah, it was nothing personal against Nate or Legal Bites. And I said to both of them multiple times that I'd be happy to do one-on-one collabs with them. It was just the format of the 3 of us. I don't know. It was a little tired. Anyways, or it was a little tired for the moment. I needed a break. So anyways, I was watching an old episode of Law & Order, and they were referring to one of the characters taking the sergeant's exam, which is an exam you have to take to become a sergeant. And there's apparently other exams after that. And I thought to myself, I have absolutely no police training of any time, but I do have legal training. So I wonder if with absolutely no preparation, whether or not I can pass these exams. So we're going to see whether or not I can ascend through the ranks of the New York Police Department based on some practice questions. How good is my legal knowledge? Can I ascend through the ranks of the police department? Let's find out. So let's figure out, can I be a police officer, and what rank police officer can I be? This will be fun. Okay. So we have different levels of examination, and we're going to do them all. So we'll be here for a little bit. So we got the entrance level examination to become a police officer. Then we got the exam to be a sergeant. And then we got the one for captain or lieutenant, which I don't know if this is the same exam or what, but they're consolidated on this site. So we're going to answer these questions, which apparently are actual questions from these various exams. These apparently are real questions. Yeah. This is not TV law. This is real law. No, the New York Police Department in reality does this. In order to ascend through the ranks, you have to take various different exams, right? So the show mentions it because it's a reality. And so they were mentioning, what character is taking the whatever exam. I was like, okay, so let's do the real thing. This is actual law. This is actual questions from an actual exam that's used by actual officers in the actual NYPD, right? So this is the real thing. I thought maybe let's see if we can do that. Fun and exciting. The video feed is looking awesome. Well, thank you. I appreciate that very much. Yeah. It was interesting because it's a little redder coming out of the video feed than I am in real life. Like because I have a monitor on the camera. The camera comes with a flip up monitor, so I can see myself in the camera. And then I can also see myself in OBS. And for whatever reason, and I don't know why, but for whatever reason, the color coming out of the camera is not the same as it is on the monitor, right? It doesn't look the same. Notably, it's a lot redder, right? So I just filtered the video to drop the redness so it more closely matches what the camera is actually seeing. So this is much closer to what I actually look like than, so yeah. And I don't know why that is, but it seems to not be the same on the HDMI input for some reason. Yeah, real law makes me sad if this is a real cop test. Apparently this is a real cop test. and we're going to figure out together whether or not we can be cops. All right, so this is the questions just to figure out, can I be a cop? Question 1. The United States Constitution provides that persons shall not be subject to unreasonable searches and or seizures. According to the preceding sentence, A, the police may not conduct a search of a person's home without a valid warrant. No. B, the police may not seize a person without establishing probable cause. No. C, non-citizens are not no. D, certain kinds of searches are forbidden. Right. That's the only information that the previous sentence provides. Right? It doesn't provide any other information. The answer is D. And the answer is D. So I get number 1 right. So I get a check mark. Let's do the next question. As in the case of other misconduct brought about by the use of alcohol, when drinking causes an employee's work to deteriorate or drop to an unacceptable level, the supervisor is responsible for corrective action. Deteriorating performance has revealed many cases of early and intermediate stages of alcoholism before other visible or physical symptoms of the disease appear. If these conditions are ignored, they are unlikely to become better through the employee's effort. They probably will only become worse. Economic loss through increased absenteeism, interpersonal problems, errors, and a reduction in levels of employee morale are bound to follow. According to the preceding paragraph, which of the following is true? A supervisor is not responsible. No. B, the physical symptoms of alcoholism usually precede. No. C, if the early stages of work deterioration to alcoholic norm, morale will be reduced. Maybe. D, an employee with a drinking problem is the best position. No. So C is the correct answer. And C is the correct answer, so I get another check mark for me. How fun. Doing so far so good. I'm becoming a police officer. Let's do another one. Question 3. Answer by selecting the choice which reflects the proper paragraph arrangement. So we've got a couple sentences that we need to rearrange into a logically flowing paragraph. Okay, it exists within individuals and in groups. That's probably not sentence 1. An ill-conceived act of a supervisor or an intemperate outburst, the application of an unjust penalty, a display of partiality, an act of fairness, or the like, may adversely affect morale of the group of the individual. Morale is a fluctuating condition. It may be high or low, moving up or down as it's influenced. Okay, let's see. So morale is a fluctuating condition is the most logical start to this sentence. Then it would be, so that's 3. Then it would be 1. It exists within individual groups. Then it would be 4. Then it would be 2. So the correct order is 3, 1, 2, 4. Is that an option? Apparently not. Apparently 3, 1, 4, 2. Oh, that's right. Yeah, 3, 1, 4, 2. That's right. So the correct answer is C. And I get that correct. Great. Next question. Answer by selecting the choice which reflects a proper paragraph arrangement of the sentence. So we're doing this again with the rearranging sentences. 1, it shut down 3 nuclear reactors that were still producing plutonium for nuclear arms. That's probably not the beginning of this paragraph. These moves will help reduce and secure the volume of fissionable material in circulation, thereby eliminating the chance that other countries with nuclear ambitions can get their hand on the material. That seems like that would flow from sentence 1. Sentence 3. Amid all the talk about renewed rivalry, Russia this week took 2 welcoming steps towards nuclear cooperation. That sentence goes first, right? So 3, 1, and 2. And then 4. And it agreed to mutual monitoring, which has to come after. So the correct order is 3, 3, 1, 4, 2. 3, 4, 1, 2. I guess that would also work. It would work either way around. It would work either way around. So 3, 1, 4, 2. Okay. Yeah. All right. A. And the answer is A. So I get a check mark. So far, so good. My odds of becoming a police officer are looking better with every passing moment. Was this written during the Cold War? I don't know when it was written, but it doesn't matter when it was written, because the whole point is to put the sentences into a logical flow. So it doesn't matter, because the logical flow would flow equally well. So it could be about literally anything. It doesn't matter, right? It's just, how would this logically flow in a paragraph? I'm like, yeah, okay, that's easy enough. Okay. Question 5. No factual information is required to answer this question. Okay. Use good judgment and reasoning to arrive at the correct answer. So this is a logic problem. Okay. Mary is taller than Jane but shorter than Dale. Okay. Well, I might have to write something down for this one. Mary is taller than Jane but shorter than Dale. So it's Jane, Mary, Dale. Jane, Mary, Dale. Okay. Fred is taller than Mary, so offshoot. But shorter than Stephen. Oh, Fred is taller than Mary, but shorter than Stephen. So Fred is shorter than Stephen. Wait. Yeah. Question 3. Dale is shorter than Stephen. But taller than Elizabeth. Shorter than Stephen, but taller than Elizabeth. Okay, and E comes this way in my increasingly bizarre looking flowchart. Elizabeth is taller than Mary, so this way, but not so tall as Fred. So she's shorter than Fred. So this is the most bizarre looking flowchart I've ever had in my life. Conclusion. Dale is taller than Fred. Okay. I don't think there's enough facts to support the conclusion if I did my flowchart right. EMDFSD. I don't think there's enough facts to reach the conclusion. So I'm going to try C. Yep. I got my flowchart right. Yeah, you want to see my work on that one? In my bizarre ass flowchart? Yeah, there's my badass flowchart, right? J is shorter than M, shorter than D. E is shorter than F, shorter than S. D is shorter than S. But we don't have enough information about the relationship between D and F. So because we don't have any pathway from D to F. So yeah, there's my bizarre ass flowchart that worked on that one. So yeah, great. Next. No factual information is used to require this question. Oh, good. We have another flowchart. How fun. Use good judgment and reasoning to arrive at the correct answer. Main Street is between Spring Street and Glen Boulevard. Okay. So that's G goes to M, goes to S. Hawley Avenue is 1 block south of Spring Street. 1 block south. Okay. I can do that. Okay. And 3 blocks. Oh, 3 blocks north. Oh, okay, so wait. Hawley Avenue is 1 block south. Yeah, well, Hawley Avenue is 1 block south and 3 blocks north of Main Street. Okay. So that's from H to M south, and this is 3. Great. Glen Street is 5 blocks south of M. Okay. Wait, Glen Street. Okay, wait. Glen Street? Do you think this is written? Do you think there's an error in this question? Do you think there's an error in this question? Because statement number 1 refers to Glen Boulevard. 3 refers to Glen Street. Do you think there's a typo in this question? Because there's 2 different Glens. Glen Street and Glen Boulevard are not the same thing. Okay, so this will be Glen Boulevard. Glen Street is 5 blocks south of Elm. Okay, so that's M2 GS. And 4 blocks south. Wait. 5 blocks south of M. I'm sorry. And 4 blocks south of Main. So this is 4. And then I got another one, E. And that is 5. All the streets mentioned are parallel to one another. Okay. So they're all arranged north to south. Okay. What is the answer on D? I don't know. All right. Conclusion. Elm is south of Spring. Don't know. And Hawley. Don't know. I think C. Okay, well, apparently it was A. So that's one wrong for me. Very sad. Very sad. So 1 and 4. Main Street is between Spring Street and Glen Boulevard. Okay. All the streets. No, it's not. Oh, 1 through 4? Well, all right. We'll take their word for it, I guess. We missed one. It's very sad for us. We can't be perfect, right? Answer by selecting the choice which reflects a proper paragraph arrangement in the sentences. Therefore, it's incumbent. No, that can't be first, right? Delinquent acts, particularly those under the age of 16, are a cause of concern. That could be the start of the sentence. On many occasions, they've inflicted serious injuries to officers. Some young delinquents are capable of causing harm. So the correct order is 2, 4, 3, 1. The answer is C, and I get another point. Let's go on. No factual information is required. Oh my God, what is with this logic questions? George is older than Tom. Okay, so T goes to G. Jim is younger than George, so he goes over here. Oh, Jim is younger than George. Yeah, that's the correct order. Frank is older than Jim. If the first two... Sorry, emergency alert. Anyway, if the first 2 statements are true, Frank is older than Jim. There's no way to solve this problem because Frank is not mentioned in any other question, right? Frank is older than Jim is the conclusion. Frank is not mentioned in the first 2 sentences. George is older than Tom. Jim is younger than George. How are you getting to anything about Frank? Right? You can't get to Frank. He's not mentioned. How you get this doesn't make any sense. Uncertain. Yeah, that's the right answer. That's a gimme if you're paying attention. No factual information is required. Use good judgment and reasoning. Okay. Chris runs faster than Kevin. Tom runs faster than Chris. Tom is not as fast as Kevin. Okay, let's see. Chris runs faster than Kevin. That's a K. No, Chris runs faster than Kevin. Tom runs faster than Chris. Tom is not as fast as Kevin. Yes, he is. That's false. He's much faster. False. B. Next. Question 10. I'm seeing a pattern here. Eleanor reads faster than Dawn. Dawn goes to E. Mary reads faster than Eleanor. Okay. D-E-M. Mary reads slower than Dawn. No. Next. I'm running out of paper here. Kevin is more intelligent than Thomas. Chris is more intelligent than Anthony. Kevin is more intelligent than Anthony. We have no way of knowing because there's no relationship between the two. C, uncertain. Next. No fact. I'm getting a little bit tired. Can I get a variety of questions? It's like, okay, it's all logical reasoning. Okay, fine. Z is north of Y. Okay. Y is north of X. Okay. X is south of Z. Yes, it sure is. That is true. Fantastic. Next. No factual information. Oh my God. All right. On the last day of diet, on their latest diet, Tom, Frank, George, and Kevin lost a combined total of 260. Okay. So that's T plus F plus G plus K equals 260. Fine. Tom lost twice as much as George. Okay. 2G equals T. George lost half as much as the man who lost most. Okay, so George is one half of somebody. Kevin lost 80 pounds. K equals 80. Okay. Let's see. All right. So that means we can remove K from the equation and we can get down to 180 for them all combined. Okay, now what? Tom lost 100 pounds. Well, let's see. Tom lost twice as much as George. Okay, so in this hypothetical, that's true. 150, 30, 80. Wait a second. Yeah. G is someone who lost the most. Two G equals T. 1/2 G equals Mystery Man. Two G would equal T in this hypothetical. I'm not sure we strictly speaking have enough to form the conclusion, but it checks out, so I'm going to say A. Damn it, I should have gone with my instinct and said C. That's my fail. I should have gone with my instinct and said C. Yeah, that was my bad. Sorry, that's my bad. Yeah. Question 14. Yet another logic problem. Frank's office is 2 floors above George. George's office is 1 floor below the only man in the building whose birthday is today. Frank's office is on the 4th floor. which means that George's office is 3. And Tom's office apparently is also on 3. Today is Frank's birthday. Yeah. Is one floor below the... Oh, no, this is trickily worded. This is trickily worded. You got to pay attention to this one, right? So George is the only one who has a birthday today. But is not necessarily the only person on the floor. Yeah. Today is Frank's birthday. No, there's not enough facts to support that conclusion. See? B? Frank's office is 2 floors. Oh, well, that's what I made a mistake on. Frank's office is 2 floors above George's. That was my mistake. I wrote down the wrong number. I wrote down 4 instead of 5. That's why I got it wrong. Damn it. See, this is what happens when you don't pay attention, kids. You make mistakes. And yet another logical reasoning problem. I'm getting a little bit sick of this at this point. Brooks is perpendicular to Lotus. Lotus is parallel to Walter. Okay. Brooks is perpendicular to Lotus. Lotus is parallel to W. Brooks Avenue is parallel to Oak. Okay. Conclusion. Willis Avenue is parallel to the streets that are perpendicular to Lotus. Yes. Conclusion. Willis Avenue is particular. Yes, that would be true. A. Damn it. Well, I got 11 out of 15. I got 11 out of 15. So, I don't know if that's a good score or not. But I got 11 out of 15 to become an officer. So, I did better than 2/3. What is 11 divided by 15? Hold on. What is 11 divided by 15? 73%. 73%. That's probably passing. It's probably passing. Okay. Let's see if we can elevate ourselves from police officer to sergeant. Let's see if we can get promoted. It's passing. Is there a time limit? Probably, but I'm assuming we're well below the time limit. Okay. For the sergeant's exam. You are a police officer, yay, who is employed by the county of D. While on patrol in D, you stop a person on the street who you reasonably suspect has committed a misdemeanor, defined in the penal law. Okay, so it's a Terry stop. You ask this person to identify himself and give an explanation. The person refuses to cooperate. Under the following, what should you do? Arrest the person for obstruction. Detain the person. No. Release the person if there's no probable cause. Arrest the person if you have reasonable suspicion. You can't do that. You have to have probable cause. The correct answer is C. Yes. Don't fall for arrest because the suspect refused to cooperate. Arrest must be based on reasonable cause to believe, which is the same as probable cause. Is it, though? I've literally never heard probable cause called reasonable cause to believe. Ever. But, okay, let's go with that. That's a point. Apparently, reasonable cause to believe and probable cause are the same thing. Been a lawyer for 14 years, and this has apparently escaped my attention somehow. Okay. Question number 2. Nuvi gives me $20 to say thank you for 1,000 videos. Nuvi, you are very, very welcome, and I appreciate your super chat and all the people who are giving me super chats, and I feel like I missed an earlier super chat somewhere along the line. $4.99 from Katie Fulton. This question makes me question how I tolerate any and all entrance exams. Bless you, and sending you all the Clemson love. Well, thank you, Katie. I appreciate that. Clemson love forever. Always Clemson. Clemson forever. Clemson's the best. Thank you for the Clemson love. That was very nice. Aww. Thank you. $5 Canadian from Blue, who gives me two butterflies and an anchor. Okay, thank you, Blue. I appreciate all that. Nuvi, that was a very generous super chat. That's good. All right, anyways. A search warrant application may be filed with the appropriate court by all the following: a police officer, district attorney, a public servant in connection with his duties, a school teacher which receives state funds. Well, D is definitely wrong. So D is, a private school teacher cannot file a warrant application. Deep thoughts, right? That's 2 questions right. Next. Andrew says, go Gamecocks. I'll let a moderator decide whether or not to ban Andrew for his blasphemy. Probation Officer Mullins arrests Roger on the basis of a reasonable cause to believe, which apparently is the same thing as probable cause somehow, that Roger committed a felony. While booking Roger, the probation officer Mullins learns that Roger could not have committed the felony because he was in jail at the time. Based on the following, he should release him. That would be C. When probable cause fails, you no longer have cause. So, okay. Question number 4. Roger is a clerk in a beer distributing company. He sells beer to T, who is 20 years of age, but who produced a fraudulent driver's license which showed her to be 22. Under these circumstances, committed no offense, unlawfully dealing with a child first degree, endangerment of welfare, D has an affirmative defense. D has affirmative defense sounds like the right answer. Apparently it's B, unlawfully dealing with a child in the first degree. Okay, well, all right. Okay, noted. 169 from Dr. Per Esquire. Thank you very much for the thing. I appreciate it. Probable cause is equivalent to reasonable cause to believe that such person has committed a crime. Okay. All right. Apparently. I've never heard it called anything else but fine. But probable cause, but sure. Question number 5. A 15-year-old male who engages in deviant sexual intercourse with another male who's 10 years of age should be processed for criminal court, should be processed for family court, is guilty of the crime of sexual act in the first degree, is guilty of the crime of sexual misconduct. Well, I don't know New York law this well, but let's think about it logically. So it's a 10-year-old. So that's probably below some threshold, right? For something. So should be processed by the criminal court. But it's a 15-year-old. So I don't know. I assume you can charge him juvenilely. So I don't know that A or B can be correct on its face. I assume A and B are both options, but I assume that neither one is correct on its face. So are we guilty of sexual act in the first degree or of sexual misconduct? I'm going to go with C. It sounds more promising. Let's say C. B. Damn it. He's not a juvenile offender unless he used force or the 10-year-old was physically helpless. Depending on the wording, examiners may erroneously want to answer criminal conduct act in the first degree. Oh, okay. So this is great because they can't agree on what the answer is. What kind of testing company is this? So they say he's not a juvenile offender unless he is forced or the 10-year-old was physically helpless. And then they say, depending on the wording, the examiners, that would be the people that are administrating the test, the examiners may erroneously want the answer to be C. How am I supposed to score this? I guess I'll give myself a half. Okay. I'm not sure how I got half a point, but I apparently did. Okay. Yeah. Question number 6. As the supervisor of patrol. Uh-oh, did my streams drop? Oh, no, it's back. Yay. Okay. I thought my stream dropped there for a second. Yeah, I was maybe right. Oh. Question 6. As the supervisor of patrol, you observe that when an assignment is given by the dispatcher to Sector Adam, the patrol unit to Sector Boy also responds. Your response to the situation should be, ignore it since backup is usually necessary. Advise the patrol units as to which assignments require more than one patrol unit. Advise the unit involved to cease this practice and warn the members. Refer the matter to your correcting officer. C can't possibly be correct. Advise the patrol units as to which assignments require more than one. No, that sounds dumb. B sounds dumb. So apparently my viable options are A, ignore it, or D, refer the matter to my commanding officer. Which of these makes more logical sense? I feel like the real world answer to this has got to be A. I mean, regardless of what the regardless of what the answer in the book has got, I feel like the real world answer to this has got to be A. But I'm the supervisor of patrol. So formally, I'm probably supposed to do something about this. So I guess I'll refer the matter to my commanding officer because that sounds dumb. C. Advise the units to cease this practice and warn the members involved that disciplinary action will follow if the practice continues. Really? That was the one I eliminated first out of hand. Don't be suckered into B. It sounds good but isn't. Remember when Sector Boy responds to Sector M, the boy isn't being covered. If evildoers wanted, they could stop a sector with some well-placed phone calls. Really? I'm supposed to advise the unit to cease the practice and warn them of disciplinary action. Really? Okay. I have a feeling that is not the real world answer. Question number 7. A newly assigned police officer asks you, his patrol supervisor, what he should do if he's the first to arrive at the scene of a bomb threat. Okay, so he's newly assigned. He's new on the job. Okay. Your most appropriate response should tell him to order the evacuation of the building. Sounds logical. Advise him to conduct a search. No, probably evacuation is better, and he's not qualified for it anyway. Tell him to ask the person in charge of the building whether or not he wants the building evacuated. That's probably correct. Advise him about the types of devices where capable of being disarmed by him. No, that sounds dumb. He's a new officer. He's in no way qualified to handle a bomb. And I'm going to say the right answer here is C. Ask the building what they want to do. So, is it C? Yes. Don't fall for A. Choice C is the answer according to just about all sources. Okay, great. Ask them what they want to do. That sounds right. Fine. Question 8. The primary objective of selective enforcement is to reduce serious accidents, to provide a base for investigation data, to promote public awareness, to reduce traffic accidents. Okay. So apparently, this is a traffic-specific concept, apparently. So the primary objective is selective enforcement. Reduce serious accidents. So we're going to select for people that are really speeding. Provide a basis for investigation data. That sounds possible. To promote public awareness, that sounds illogical. To reduce all traffic accidents, well, that has to be illogical because it's selective. So D and C seem wrong. Do we think that the primary basis of selecting who we're going to ticket for speeding is to reduce serious accidents or provide a basis for accident investigation data? I think A has got to be the right answer. This is bullshit. This is bullshit. This is bullshit. I'm going to disagree. I'm going to disagree with either the test administrators or the people who are scoring this for the private company. The primary objective of selective enforcement is to reduce all traffic accidents. That can't possibly be correct. It can't possibly be correct because it's selective. How can the primary basis be to reduce all if we're selective? Those two words don't go together. It's a logical fail. It's a logical fail. How can the primary objective of something that's selective be to reduce all? How do selective and all go together as concepts? If the primary objective of selective enforcement really were to reduce all traffic accidents, then you just do selective enforcement all the time because that's your primary objective. There's no way this is right. And if this is right, I take quibbles with the people who are creating the exam. Selective and all do not go together in the same thought. This is dumb. But I won't give myself credit for it, even though I really feel like I should. Question number 9. Of the following, which best states which is the fundamental factor in success of police-community relationships is a formal unit to deal with police-community relations, the conduct of individual officers on patrol, that sounds promising, the employment of police-community relationships, no, the cooperation that exists between management and media, no. B sounds correct. The conduct of the individual officers, yeah. That's the right answer. I'm on question 9, and I've gotten 5.5 correct, so I'm doing better than coin flips, so yeah. Question 10. There can never be enough power to satisfy all people who yearn for power. Truth. What one group gains, another group loses. I don't know if that's necessarily true, but yeah. The statement below which best supports the above is, few people are content with power. No. Few people are content with the power they have. That's true. Power is always shifting from one group to another. There's a limited amount of power that exists at any time. You know, D is the most logical conclusion. D is the most logical conclusion because one group gains, another group loses, must mean it's limited. So D is the most logical conclusion, and this is dumb. Yeah, D is the most logical conclusion. Yeah. D is the most logical conclusion. Question 11. As a patrol supervisor, you're ordered by your boss to take a course of action which you personally consider to be erroneous. How erroneous? You discuss this with your boss, and his response is, you have your orders, carry them out. Under these circumstances, well, you should carry them out unless, you know that they're illegal. Carry out the orders given to you without comment to your subordinates about your opinion. That's probably true. Ask your boss to go on the record. No, not necessarily. Go over your boss's head to CO. You could do that. Carry out the order in part, leaving apart the disagreement. Probably the correct... I'm going to imagine that in this situation, we want to respect chain of command. So going off our boss's head is probably wrong. Ask your boss to go on the record by putting it in writing. That sounds wrong. Carry out the order in part seems wrong. So A, carry out the orders given to you without comment to your subordinates. That seems proper. Yeah. You must obey all lawful orders, but in non-emergencies, you owe your boss and department sufficient loyalty to speak up when you believe something is wrong. Yep. Get that one right. Next. Question 12. Employee complaints should be settled whenever possible by which of the following? The first line supervisor, the head of personnel, that sounds right, the commanding officer, the line organization such as the PBA. The head of personnel sounds like the place to go for complaints. The first line supervisor, really? Oh, whenever possible. That makes sense. Yeah, that makes sense. Okay, yeah, I probably should have gone if I had thought about it for another half second. Question 13. As a patrol supervisor, you respond to a street incident where one of your subordinates has requested your appearance. When you debrief your subordinate, the following facts emerge. T complains that she was assaulted and robbed. T identifies R as perpetrator. R, who is present, denies. T is bruised and bleeding, is excited, and has been drinking. T maintains R committed the crime. You advise your subordinate to arrest and search Roger. You have probable cause, so it makes logical sense. Which of the following is a valid statement? It was not legal since T had been drinking and R denied it. That's bullshit. It was legal because T unequivocally identified Roger. No, that's not the reason it's legal. It was not legal since Roger made no effort to leave. No. It was legal since the statement made by T provided at least reasonable suspicion. That's wrong, because you can't arrest on reasonable suspicion. So I guess the correct answer must be B. The correct answer must be B. By process of elimination. Yeah. That's not the reason why. The reason why is because you have probable cause. But, okay. Question 14. You are a supervising detective, and you're preparing to question a witness who you know to be unreliable. It would be best for you to let the witness talk as much as he wants, not permit the witness to volunteer information, give the witness Miranda, no, he's a witness, so no. D, ask simple questions one at a time to prevent the witness from wandering in his answers. A or C? I think we're going to go with D. Damn it. I got that one wrong. I had a 50-50 and I got it wrong. Question 15. In the investigation of a fatal motor accident, of the following, who must make or arrange to make tests of the victim's blood? Well, let's see. It's a fatal accident. So the coroner is the most logical person. The patrol supervisor? No. The investigating officer? No. Department physician? No. Coroner sounds right. C. Yeah. Okay. So of 15, I got 9.5. What is 9.5 divided by 15? 63%. I don't know, man. I'm not so sure about that passing percentage. I don't know. I'm not sure whether or not I'm going to become a sergeant or not. All right, let's skip off. Let's skip to lieutenant captain. Let's see if I can get promoted from sergeant to lieutenant or captain. All right. These tests sucks. It's like the free IQ test. These apparently are real questions. These are apparently real questions from the exam. Okay. You are assigned to supervise a detail of police officers at the scene of a labor dispute. The workers of a warehouse have gone on strike over a disagreement over the interpretation of a labor contract. The union has drawn up picket lines outside the company and has kept them staffed for 3 weeks. Feelings on both sides have grown intense and violence has become a threat. Which of the following would most likely cause a problem? Okay, what would exasperate tensions? A, shortly after arriving on the scene, you call together a picket captain and management to discuss ground rules. That doesn't sound bad. B, several of the officers refuse an offer to use the company restrooms and instead walk several blocks. Doubtful. How would they notice? I mean, no. C, the officers opened a picket line to allow the entry. That sounds wrong. D, that sounds like a bad thing. When opening the picket line, they keep their backs. No, that sounds good. C, opening the picket line to allow a delivery truck sounds like the right answer. And it is the right answer. 1 point for me. Next question. Null ID. Null ID says, happy 1000th video day, Uncivil Law. Well, thank you. Thank you for your, and then she was timed up by stream bots for yelling. Oh, I'm sorry. The bot can be a cruel mistress. But thank you for the congratulations. I wonder if I can undelete it. Can I undelete the message? Do I have power? Hold on. Pin message. I can pin it. Let's pin the message. See what that does. Yeah. There you go. I've pinned it. There you go. I've undeleted it by pinning the message. Next answer. Next question. Question 2. Which of the following statements regarding delegation of work to subordinates is not correct? Some supervisors are reluctant to develop subordinates because of fear of future competition. I believe that. Supervisors should be encouraged to delegate all work to the lowest possible level. That sounds right. Supervisors who refuse to allow anything to be done except under their control are cause of crippling bottlenecks. That sounds right. Supervisors should take back tasks to delegated subordinates who, although capable of doing so, are reluctant to make the required decisions. They all kind of sound right. Supervisors are reluctant to develop subordinates because of fear of future competition. That sounds right. Supervisors should be encouraged to delegate all work to the lowest possible level. That sounds right. Supervisors who refuse to allow anything to be done except under their control are cause of crippling bottlenecks, which slow operations. That's got to be right. Supervisors should take back tasks delegated to subordinates who, although capable of doing so, are reluctant to make required decisions. But they do make the decisions? I guess D? Okay, I guess D was the right answer. It seemed like the least wrong. Do not take back work assigned to a subordinate who is qualified. Okay. Question 3. If a threat is made against a business establishment, a public building such as a school, office complex, or warehouse, the hidden bomb is to explode. The decision is whether the occupants should be evacuated is the person in charge of the premises. We know that from an earlier question, and I'm still giving myself credit. Question 4. After a search of the theater was conducted and no bomb was found, Rikita Law says, woohoo, 1,000 videos. Are you doing an ethics practice exam? Rolling on the floor laughing. No, I'm not doing an ethics practice exam. It's actually more stupid than that, Nick. I was watching an episode of Law and Order today, as one does. And in the episode of Law and Order, they mentioned that one of the characters was going to take the sergeant's exam. And I'm like, what would be fun? What would be fun is if with no practice and no prep, what if I took the exam and see how well I would do? So far, I've passed the exam to become a new officer. It looks like I might have failed the exam to become a sergeant. But we're going to see whether or not I can pass the exam to become a lieutenant or captain. And so far, we're doing pretty well. Thank you very much. Yeah, thank you very much for the super chat, Nick. Yeah, this is what we're doing now. We're seeing, can I become a police officer of various different ranks? So anyways, after the search of a theater was conducted and no bomb was found, the sergeant informed the theater manager the building was safe. In this instance, the sergeant's actions were proper. As the supervising officer at the scene of occurrence must be decisive. No. Improper, as the sergeant has no immediate control of the management. No. Proper, as cooperation between police and legitimate business person is highly recommended. Sounds plausible. Improper, as such procedure might involve liability for the department in event persons reoccupy the theater and are killed or injured from explosion that was not found. Is there really liability for that? What would be the liability theory? What would be the liability theory? Maybe there's some specific liability in New York law. Maybe there's a New York, I have to consider that. Maybe there's a New York tort law that would give liability for some reason. Mike said, ask Nick about your half point. I mean, he wouldn't know the answer either. Yeah. Yeah, I think D. And the correct answer is D. Point for me. Question 5. If a police officer takes a child under 16 into custody, or such a child is delivered to him by an adult who has taken the child into custody, the police officer is required to make notification to the parents. I know the answer without reading it. The child's parent. It's A. Yeah. That's 5 for 5. Next, question 6. Frank, age 15, is in the process of committing a robbery. In the immediate flight therefrom, Frank causes physical injury to some other person. Based on the above, Frank committed robbery in the second degree. Yes. Frank committed assault in the second degree. Yes. Frank should be processed as a juvenile offender if arrested. Yes, that would be the initial right answer. If he's going to be elevated, that would happen another time. But the initial processing would be as a juvenile offender because they're under the age of 18. So all 3 are correct, and I get the right answer. Question 7. In spite of the necessity for military discipline, it must be realized, however, that police officer differs from a soldier, in that the former, the police officer, must be allowed a considerable degree of discretion. Police officers get more discretion than soldiers. Okay. Therefore, it's unwise for a commanding officer to impose upon the subordinate a discipline which requires blind obedience and complete dependence. The command of a police department necessitates a high degree of leadership in order that subordinates will cooperate as well as obey. The most accurate thought among the following is this. To impose discipline would result in complete independence? No. The command of a police department necessitates discipline which requires blind obedience? No. It's unwise for a command officer to allow a police officer a degree of discretion? No. D. A police officer more often than soldiers? Yeah, D. It's the only one that makes any logical sense, and of course it's the right answer, and I get a point for that one. I'm doing much better on my captain's exam than I was on my sergeant's exam so far. 7 for 7, baby. Let's go. Maybe the questions are just more stupid. Question number 8. Question 8. A widespread instance of unrealistic attitude towards definitions is found in the common prescription, let's define our terms, so that we all know what we're talking about. I think that's actually probably a good idea, but I get the sense I'm about to be contradicted. People often believe, having defined a word, that some kind of understanding has been established, ignoring the possibility that words in definitions often conceal even more serious confusions and ambiguities. If we happen to discover this fact and try to remedy matters by defining words, we'll quickly find ourselves in a hopeless snarl. That's true, because you have to define the words that define and define the words that define. The only way to avoid the snarl is keeping definitions to a minimum and to point out extensional levels wherever necessary. And in writing and speaking, this means giving specific examples. So less with definitions, more with examples. Okay, which of the following is the main point? All definitions are properly used can make it unrealistic. No. Use of concrete examples from experience provides better basis for discussion than definitions. That sounds right. Persons can best maintain mutual understanding by using definitions. That no. If person would use definitions, no. The whole thing is devoted to don't use definitions, use examples. And A, C, and D say use definitions. So they're all wrong. And B is the correct answer. Next question. Rearrange the following sentences in proper order. He tends to view such involvement, particularly if there's some kind of danger, as constituting real police work. But it's apparent that he spends considerably more time keeping order, settling disputes, finding missing children, and helping drunks than he does in responding to criminal conduct. This does not mean serious crime is unimportant to the police officer. A police officer assigned to patrol duty is typically confronted with, at most, a few serious crimes on his tour of duty. Well, 4 is the most logical place to start. He tends to view such involvement as constituting police work. That doesn't mean serious crime is unimportant, but it's apparent he spends considerable more time keeping order. So the correct order is 4, 4132, which is not an option. So 4123. I'm not sure that's the best order. 4312. 4312. That sounds right. No, it doesn't follow. 4213. 4. All right. 4123. A police officer assigned is confronted with, in most few serious crimes, who tends to view such involvement as constituting real police work. But it's apparent he spends considerable amount of time. This does not mean serious crime is not important to the police officer. I guess 4123 works as a logical flow, and it's apparently the correct answer. Okay. Oh, sorry, you can't see the whole question. I'm sorry. That's my bad. I'm sorry. I'll leave it on screen for a few more seconds. Question 10. Sergeant Jones radioed for help. The sergeant did so because the crowd was getting larger. It was 10 a.m. when he made the call. Sergeant Jones was not in uniform at the time. Which of the following presents the best information? Sergeant Jones, although not on duty, we don't know that. Although not in uniform, Sergeant Jones called for help because the crowd was getting uglier. That's not what it said. Sergeant Jones radioed for help at 10 because the crowd was getting larger. That's true. Although he was not in uniform, Sergeant Jones radioed for help at 10 a.m. because the group was getting larger. D is the best summation of everything. And, of course, that's the correct answer. 10 for 10, baby. 10 for 10. My ability to become a captain is looking better and better with every passing moment. Question 11. Frank, the rattlesnake caretaker at a local animal show, drinks to excess, becomes intoxicated, and while many people are watching another attraction, he laughingly lets rattlesnakes out among the crowd. Well, that sounds like reckless conduct to me. One of the snakes bites a spectator and the spectator dies. Based on the provisions of Article 125 of the Penal Law, Frank has committed which of the following? Okay. So we've got reckless conduct. We've got reckless conduct. And because he's a rattlesnake caretaker, so he probably knows what rattlesnakes can do and they're poisonous. So I think we're up to recklessness. So criminally negligent homicide is not the best answer. Manslaughter in the first degree, manslaughter in the second degree. Murder in the second degree. I believe, if memory serves correctly, again, coming from my many episodes of Law & Order, I believe in New York, reckless conduct can be murder. I believe in New York that reckless conduct can be murder in the second degree. So I believe the correct answer is murder in the second degree. And it is, because apparently that's depraved mind murder. Fantastic. Next question. T, age 21, engages in intercourse with Frank, who is 14. Okay, so it's a minor. T is an adult. Now, what is he guilty of? Statutory rape seems like the go-to, but it's a 14-year-old, and I'm willing to bet that's some other category. I'm willing to bet that, like, the reason it's 14, I'm willing to bet the reason it's 14 is because that triggers another level. And also, like, the years apart. So I don't think statutory rape is the best answer. Sexual misconduct doesn't sound right. Rape in the second degree sounds wrong. Rape in the third degree sounds right. Let's try rape in the third degree. No, apparently it was rape in the second degree. I thought, maybe it would be a lesser degree of rape, but apparently it's rape in the second degree. 18 or more LT. What does LT stand for? 15 is rape in the second. What is LT? 18 or more LT. What's LT? If it's an 18-year-old, it's legal. What is LT? All right, let's press on. I finally missed one. Question 13. Evidence is subdivided into three major classifications: direct, real, and circumstantial. Which of the following most clearly applies to direct evidence? It's evidence based on opinion. No. It carries the least amount of weight. No. The testimony of an eyewitness? Yes. A weapon introduced? No. It's testimony of an eyewitness. C. Final answer, and yeah. Why is the captain's exam so much easier? Why is the captain's exam so much easier? Oh, 18 or more, less than. Okay, wait. So yeah. So what? Okay, so let's go back to 12. So it's rape in the second degree, but I won't give myself. 18 or more, less than 15 is rape in the second degree. 18 or more has nothing to do with anything. 18 or more. Why are we mentioning 18 or more? It has nothing to do with anything. All right, fine. Less than 15 is rape in the second degree. I knew it was probably something special. I just didn't know what something. Okay. So, yeah. What's question number 14? An ordinary witness who is not an expert may give his opinion concerning any of the following. So an ordinary witness can give opinions as to things ordinary people would have knowledge about. They can give non-expert opinions about things an ordinary person would know. So all you have to do to be able to answer this question is it a thing that a normal person would know? Is it something a normal adult would know? If so, they can testify. So we're looking for the thing that is not something you would expect the normal adult to know. Okay, which of those things? A, whether a photograph is a good likeness of a person. He knows. That's something a normal person could figure out. B, the estimated age of a person. You're there. C, that a person seemed to be intoxicated. You're there. D, that the fire was of incendiary origin. I'm going to guess that your average person is not a fire marshal, so D is the right answer. Yep. Yeah, that's not going to fly. The perp is over 18. Oh, okay. Oh, the perp is over 18. I see. That makes sense. Okay, fair enough. Question 15. In any prosecution for issuing a bad check, it is an affirmative defense that defendant or person acting in his behalf made full satisfaction of the check within what period of dishonor? Okay, so this is going to be some New York State specific shit, which I have no way of guessing the answer to. But let's try to use a little bit of logical reasoning and see if we can logic our way into the answer by fluke. All right, so the what I've done is I've passed a bad check, but if I make good on the bad check within a certain time period, it's an affirmative defense. Okay, so the question is, what kind of time period am I going to get? 30 days seems too long. 15 days? 10 days. 30 days seems way too long. 20 days seems too long. 15 or 10 for a bad check. I'm going to say 15. A. Yeah, no, A. I had the right idea, but the wrong answer. Well, we did much better on that one. What is 13 divided by 15? 86%. 86%. So apparently I'm well on my way to becoming a police captain in New York. Excellent. Excellent. So who knew, man? Who knew that I could be a police captain in New York with absolutely no training of policemanship of any kind, but with some logical reasoning and putting paragraphs in the right order and, some intelligent guesses, I got 86% on the captain's exam. So I'm ready. I'm ready to lead an entire police department. Yay. That's nice. Yeah, I think yeah, police chief test next. I'm not sure you get a test to be police chief. Usually the police chief is appointed, right? These are non-appointed positions. I don't know when you start appointing people, but yeah, the police chief doesn't have to have any particular credentials because they're appointed by the mayor, I think. But these are all positions that are within the bureaucratic ranks as opposed to political positions that are appointed. So yeah, apparently I'm ready to become a police captain now and run an entire department. Excellent. Stella D14 asks why though? Why? Why is it appointed? I'm because why are there political positions? Well, the idea at least is the idea at least is you always want the authority to be subject to civilian authority. So the reason that you have the police chief be appointed is basically the same reason that the president of the United States is commander in chief, right? The president of the United States is commander in chief of the military, but he's non-military, which is kind of the point. The military is led by a civilian. It's kind of the point, to prevent the military from being in control. Because the military is in control, that's a whole different can of worms. Then you live in a military-run state, and that's not great. So in the same way you want the president of the United States to run the military because he's a civilian, you want the police chief to be a civilian, and you want him to be politically appointed so he's accountable politically, right? So ultimately you want the person who's heading this thing to be a civilian. So that's why. Does this explain why qualified immunity is a thing? Because a lot of people wouldn't do very well in the exam? Maybe. So this was fun. This was fun for a 1,000th video special. We had fun. I had fun. We became a police chief in New York, or a police captain in New York. I feel great. Maybe I should send in that application. I'm ready to go. Yeah, no military junta. Yeah, that's right. Yeah. Same reason that so if the police chief does bad things, the mayor or whoever can fire them, right, and appoint a different police chief who can give different directive. Since the chief of police is the head of the policy making, right? It's like, well, if the chief of police is doing a bad, fire the chief of police, hire a different chief of police. Do it? Yeah, maybe. What else should we talk about? We could do some bar questions. We could find some sample bar questions and see how good my bar exam knowledge is. What else should we do? We've been doing this for an hour 38. I don't want to end the stream yet. What else should we do? Should we do some bar exam questions and see how good I am at my bar exam? Or should we do something else? LSAT? I don't know if I want to do LSAT. Yeah. A political compass test? I've done that before. Let's look at patterns now. Yeah, I've done political compass before. I'm usually about, on the standard political compass, I'm usually about 2 to the right and about 2.5 down, give or take. They change over time, that's the point. You want me to do an LSAT? The LSAT is like logical reasoning and puzzles and stuff, and I took a bar exam, turns out I'm drunk. Bar test, what drinks? You want to do some practice LSAT? All right, we'll do some practice LSAT. Fine. Did they give me answers? Oh, Lord. Free LSAT practice test. Oh, Lord. Do I have to sign up for something? If I have to sign up for something, I'm going to be really unhappy. I don't need to work out. How do you select an answer? You don't select an answer. Complete the above quest to get the correct answer. There's no way for me to select an answer. This is broken. LSAT simple questions. Free pop quiz. This doesn't allow me to select answers either. Where's somewhere that I can actually get some LSAT questions? This doesn't allow me to select answers. Free LSAT practice test. That's what I want. I just want the test. Give me the test. Just give it to me. I don't want to create an account. I just want the... Fine, I'll connect to it with Facebook. Fucking bullshit. I don't want to tell you that information. I don't want to sign up with an account. Test guide LSAT. I just want a sample test. Varsity tutors. Logic games, logical reasoning. Oh my God. I can't find one. Khan Academy. LSAT prep from Khan. Get started. Diagnosis? What is this? Diagnosis? Okay, take a timed, full-length LSAT. Take several shorter diagnostics. Yeah, we'll do the shorter ones. This is going to make me sign up for an account too, isn't it? Apparently not. Okay. Analytical reasoning. Logical reasoning. Reading comprehension. Catalog of test questions? Just give me the questions. I can't do it. I can't do it. I can't do it. I can't get to somewhere that will actually let me take questions and answer them. I just want a test. Yeah, I guess that wasn't meant to be. I guess that wasn't meant to be. Let's see if we can do MBE practice questions. Sample bar access questions. Start now. Okay, there's 50 questions. All right, so let's do a bar exam. All right, let's do the MBE. Let's do the multi-state bar exam. All right, let's do the multi-state bar exam and see how well I do. Okay. A regulation prevents a person with a drug arrest and conviction and or those undergoing current treatment for drug abuse from working in certain state-run facilities for the safety of the general public. One employee of the Department of Treasury brought action claiming denial of equal protection and due process by taking away his right to the job. No. It's claimed that the prohibition is necessary to protect the public from potential problems, which tests the constitutionality. Rational basis. The rational basis because discrimination is generally favored with drug users? No. Because the regulation only needs to be legitimate? The answer is D, and that's the correct answer. Next. Okay, next. An inexperienced bicycle rider took her new bike for a test run. At an intersection, she could not stop for a red light and went to an intersection where she slipped off the bike. Okay. While attempting to remount it, a car came into the intersection with a green light, ran over her, causing injury. The car driver was distracted by a cell phone and received a careless driving ticket from the police. The woman filed a claim for damages, asserting the car driver was negligence per se. She claimed that a finding of negligence per se prevented the driver from asserting comparative negligence under the state statute. That can't possibly be right. Will the trial court grant the motion to preclude the man's comparative negligence? Yes, because the driver had the last chance, which abrogates comparative negligence? I don't think so. Yes, because negligence per se is a final judgment? No. No, because the common law doctrine negligence per se does not abrogate the right to apportion fault. That sounds right. No, because she entered the intersection knowing it's a red light? No. C sounds like the correct answer, and it is the correct answer. Next question. A witness in a murder case does not make the same statement faithfully, but rather he gives different versions of his observations at different times to different persons and investigators. The prosecution puts the witness on the stand at trial to tell what he observed. Defense counsel impeaches his testimony by bringing up prior inconsistent statements and accusing him of changing his story. Sounds like a very good strategy to me. The prosecution then attempts to rehabilitate his credibility by referencing prior consistent statements. Okay. Prior consistent statements are not generally admissible because they're said to be repetitive, cumulative, and unfairly bolster the witness' credibility. Will the court allow the prosecution to rehabilitate the witness? In this situation, yes. Yes, because it's being used to rehabilitate a witness whose credibility is attacked. Yes, because all prior statements are important to the consistency. Yeah, C is the correct answer, and it is the correct answer. Next question. I'm still good at bar exam questions. 2 women lived in a 1-bedroom house with 20 dogs. Okay. A dog walker who entered the house was appalled by the deplorable living conditions. The animals' excrement was deposited throughout the house. They were kept in tiny pens, and some of the animals were sick. The visitor called the SPCA a private organization. Fine. State law authorizes humane societies to receive abused or neglected animals from animal control officers. Fine. The SPCA took the animals designated by the officers. Okay. The officers then arrested the woman for neglect. At a hearing, the prosecution was unprepared and the judge dismissed the charges. The woman then sued the violation for 42 U.S.C. 1983. No. The SPCA defendants filed a motion to dismiss based on absence of state action. Oh, the SPCA is a state actor now? Is the SPCA a state actor? Just because they're eligible to receive, I don't think they're a state actor. And if it was, this sounds like there's no violation of the rights. But SPCA is moving to dismiss. Will the court grant? Yes, because there's nothing done by a humane society that involved police action. Yes, because the SPCA personnel did not act under color of law. No, because the SPCA was organized under a nonprofit certificate that was issued by the state. That's wrong. No, because the SPCA acted under an authority state statute and cooperated with state authorities. No, that doesn't sound right. I'll go with B. It was C. Because the state authorized under state statute cooperate with, or D, because they authorized state functions, so close enough to get them under color of law. I understand. We're at 75% so far. A man publishing a website wherein he billed himself as a crusader for justice and hero with special powers. He wrote mainly among consumer issues while acting like a watchdog, exposing wrongdoers. He wrote one article about a female preacher with a local church that had no affiliations and only a local blog on the internet. He wrote to say that she was conspiring with the devil to figure out how to lead people's minds astray and to live a nice sheltered role of moral superiority at the expense of inferiors. He called the woman's fashion medieval, and her hairstyle was like a bag of hot wires related to electrocuting when it comes too close. That sounds like opinion. The preacher was not amused, and she files defamation per se and demands damages. The defendant filed a motion to dismiss. Will the court grant it? Yes, because the defendant was expressing opinions more than factual assertions, and opinions are constitutionally protected. Yes, because statements about religious beliefs cannot be the subject of defamation. Ooh. That sounds right. Yeah, conspiring with the devil, how to lead minds astray. Show right of moral superiority. Yeah, now that you put it that way. Yeah, no, because the preacher's allegations are based on factual distortions. No, because her defamation cannot be subject to motion to dismiss. No, the plaintiff is always entitled to present evidence. That's bullshit. So let's see. I'm going to say A. And A is the correct answer. They're all opinion statements. Next question. A pet store opened a store in a new town. She was not aware the city council had recently passed a law prohibiting the sale of cats and dogs from a retail pet store. Okay, well, ignorance of the law is no excuse, so you know. The statute had a provision that allowed pet stores to give space to a non-profit humane society to adopt animals from the store. The owner sued the city in federal court, claiming a violation of due process and equal protection. No. The court used rational basis to conclude the state served a legitimate interest. Sure. The pet store owner appealed. Will the appeal court affirm? Yes. Yes, because the pet store owner was not treated differently than a pet store. Yes, because the correct test requires only the law in question will satisfy any set of facts that could establish rational basis for achieving legitimate government ends. No, the pet store has the pet store owner has a vested constitutional right to earn a living. No, because the ordinance is so invidiously discriminatory that must pass strict scrutiny. No. So I'm going to say B is the correct answer, and B is the correct answer. Next question. So I'm doing pretty well in my bar exam questions. You guys can tell me. Peter Siegel says, what are we talking about today? Well, Siegel, earlier today we did a can I be a police officer / police sergeant / police captain in New York. And now we're doing bar questions. We're doing bar exam questions. And so far I'm 5 for 6. So, I'm still pretty good on the bar exam. So I haven't studied for the bar exam in 15 years, but apparently I'm still pretty good at it. 2 companies, a construction company and a landscaping firm, got into a contract dispute over the nature of landscaping services. The landscaping firm was incorporated in New York and did all the business in the state. Okay. The construction company was an LLC that had been filed in New York, with its members being domiciled in Pennsylvania, Virginia, and Vermont and Virginia. Okay. They claim diversity jurisdiction. No. The landscaping firm is incorporated in New York. The construction company is incorporated in New York. There's not diversity. So the answer is D, which of course is the correct answer. 6 for 7. Next. These are not New York bar exam questions. These are MBE questions. These are multi-stated questions. These are the question every state uses. Every state uses the MBE as part of their exams. So this is part of the bar exam. So these are not New York specific questions. These are just questions you would see if you were a lawyer taking the bar exam in any state. So, yeah. Michael says he knows someone in Mississippi that could use my help for the bar. That woman needs help beyond my ability. I'll tell you what. A homeowner buys a new leaf blower. Is so impressed with his power, he gets carried away and blows a large amount of his work on the neighbor's yard. That would be trespassing. In addition to leaves, he also blew large amounts of pest-inflated debris on the neighbor's property. That's trespassing. The material is accumulated in large, unsightly piles and caused damage to the neighbor's healthy plants. Yeah, you're going to be responsible for that. He has paid workers to haul the material away and incurs expense to replace the flowers. Okay. The neighbor sues for tort of trespass. The homeowner files a motion to dismiss because the neighbor cannot prove he acted intentionally with trespass or to do harm. Trespass is not an intentional based offense in civil law, and harm is not negligent. So the court will not dismiss Because there's been full repudiation, though, it's, yes, you're liable for $1. Okay. Will the court grant the motion dismissed? No. Because the infected debris constituted abnormally dangerous condition and can be held strictly liable for trespass. No, because trespass is based on intentional act of entering the land or sending something on the land. Actor does not have to have ability to harm. Yeah. Is it A? I don't think it's abnormally dangerous. I think it's B. Yeah, it's B. Great. Got that one right. Next. Is everyone having fun? If you guys are not having fun at any point, just let me know that you're not having fun. You know? So, and I'll be happy to help. I try to make good content that you guys will enjoy. I try to make content that's interesting. And, you know, I think how well will I do on a bar exam 15 years later might be interesting, but, you know, you guys let me know what's entertaining for you. Okay. A man sued a manufacturer of video and home theater equipment after his home theater started a fire, destroying the equipment and part of his home. Okay. He sued the manufacturer in federal court. Okay. At trial, defendants moved to preclude the report and testimony of the expert. Okay. Defendants claim bias, lack of scientific support, failure to conduct testing, divergence of opinion among experts. That's not going to work. And the expert was trained for large commercial fires. Yeah. The expert has investigated over 500 files, wrote a book that's used in courses nationwide, and taught a course in forensic fire. Sounds pretty qualified to me. Her report ruled out all other possible causes. The court did a gatekeeping review as required by the rules, and ruled the expert was highly qualified and she used scientific methodology. Defendant appeals the ruling. Is the appellate court likely to go on the other side? No. No, the court did the required gatekeeping and found the witness was not only qualified but accepted methodologies. No, the court has absolute discretion. That's not right. The correct answer is C, and of course it's the correct answer. Yellow Jacket Essay says, congrats on the milestone on civil law. You're correct. I appreciate that. And I didn't have that question on screen as I was reading it. I apologize. Forgot to switch back. So far, we are 8 for 9. Let's see if we can go 9 for 10. Yeah, this is the question. I'll leave it on screen for a second so you guys can read. But yeah, basically we have an expert who's written the book, has investigated 500 fires. He's taught forensic courses in the university on fires. The court says he's highly qualified. Is the appellate court likely to go against it? No. No, he's a suitable expert. Easy. You know? So, yeah, that makes sense. The president and sole stockholder of a small business negotiated to sell the business to an individual investor. The parties met and signed a letter agreement, which set forth price, down payment, financing terms, assets to be included, and a host of other details. The financing close date was not stated, but purchasers left a down payment of $20,000 with the seller. The letter stated that terms compromised their essential agreement, but a formal document may be drafted by the attorneys. So we're going to get into whether or not this is a contract, right? Because the letter itself states a formal document will be drafted, but also says this is the essential agreement. So is this a contract is the question they're going to ask me. Before that happened, the seller returned checks and refused to perform. The investor bought an equity action for specific performance to compel the sale. Yeah, you don't have a contract, or do you? I think you could bring it in law, actually, and say we have a contract, not just equity. Well, the equity court ruled that it was complete and binding contract that must be specifically performed. Will the appellate court affirm? Okay, I'm not so sure about this one, but let's see what we got. No, because the closing date was left out and attorneys were supposed to compose the final track with all remaining details. I don't think the closing date being left out is going to be a problem. No, because this type of letter is basically a gentleman's agreement that does not intend to be legally binding. Yes, because the letter intent is legally binding if it sets forth price, describes business, and is signed. Sounds right. Yes, because the letter contains all the essential terms required for a contract to be enforced as contract. But he's bringing an equity action. Why is he bringing an equity action? He could bring an action in law. So can the appellate court, strictly speaking, affirm this if we're in a state that separates equity and law? Because I think there are still 3 left for some reason that passes my understanding. So since this is coming from an equity court, is it possible for the courts of appeal to enforce it as a contract? I honestly don't know. I'm going to go with C. Because I don't think it's possible for a court of appeal, if you're in a state that separates law and equity, and there's still 3 of them for God knows what reason, if you're in a state that separates law and equity, and you bring the argument in equity, I don't think you can get an appellate decision that says this is a legal contract. I don't think that's possible. So I'm going to say C and cross my fingers. Apparently it's D. All right, let's read this. Where the parties have settled upon essential term and the only remaining act to be done is formalization, the latter is not inconsistent with the present contract. Where equity court rules there's a binding contract because all the essential terms were included, appellate court will not reverse. Can an equity court really hold that there's a binding contract? If there's a binding contract, that's a legal issue, not an equity issue. Yeah, I don't know about that one. Well, I got 80% on the first 10. Yeah, I got 80% on the first 10, which is more than enough to pass. Yeah, I don't think the equity court can do that. They specifically said it's an equity court. They specifically say it's an equity court. It's not just that the issue was brought in equity, right? Because if it's brought in equity in a court that does both law and equity, they can probably do that. Because the court that does both can say, well, not so much with the equity, but I'll give you a legal remedy, right? But this is specifically an equity court. And saying there's a binding legal contract is a legal determination, not an equitable determination. So, I guess I'm wrong, but I don't know why exactly. The equity court ruled that there was a complete and binding contract that must be performed. If there's a contract that has to be performed, that's an issue of law. If there's a contract that's binding, that's an issue of law, not of equity. So I think you brought the wrong cause of action. So I don't think this is a decision the equity court can reach. And I don't think it's a court decision the Court of Appeals can reach either. You know? I have my doubts on that one. Well, we got 80% right at least. We got 80% of the first 10 right. So I still have some chops, on the bar exam. So, and I'm not so sure about this last one. Yeah. But okay. I would get this wrong on the real bar exam too. I would get it wrong. Because it doesn't, I am. Okay. Yeah. Anyways. Thank you guys for being here. Thank you guys for being part of my Uncivil Law family. Thank you for all the super chats you've given today. Thank you for your encouragement. Thank you for your positive feedback. Thank you for all the things that you help me do. I continue to try to find the content that you guys will like and look at my analytics to try to figure it out and your comments to figure it out. you know, and I really appreciate it. I really appreciate you're all here. We have 26,000 subscribers and 1,000 videos. 1,000 videos uploaded to the channel. Ricardo Ospania gives $2 and say, thanks on the 1,000 videos. Do you want to make a tier list? A tier list of what? Tier list of what? Michael says, thank you for the content. French says, thanks for the educational content. You're welcome. All right, well, this has been fun. We're continuing to produce more content. And I thank you for all being here. If you enjoyed this stream of our 1,000th video, if you'd be so kind as to give it a like. And if you're not subscribed already, please subscribe. I'm not beyond begging. I could use the subscriptions. So after 1,000 videos is finally enough to support you full time? It's not. It's not enough to support me full time. The number of videos is not the key factor. The key factor is the subscribers. That's the key number to look at. More subscribers implies more AdSense revenue. Implies my videos get more often. Also implies my ability to get brand deals or something at some point. Like, you know. So the key number that will indicate my likelihood to be able to go full time is subscribers. It's not exactly linear, but it's the best metric to look at. So it's not exactly like if I had 52,000 subscribers, I'd be making twice as much money as I do now. So it's not exactly 1-to-1, but it's the closest mark to look at and see, well, how successful is the channel as subscribers. Yeah, engagement also helps, but subscribers are really good. So yeah. Anyways, I'm gonna sign off. Till later, my friends. Cheers and goodbye.